Well, we have one. Okay, let's see here.
Very intimate Q&A.
What's that?
It'll be a very intimate Q&A.
There we go. Hey, one-on-one time. You can't beat that.
Yeah, this morning they did it where we could see everybody. It was like a breakfast meeting.
Mm-hmm.
It was really nice because instead of having a Q&A, they literally raised their hands. And the president would point to them. So it was more like normal.
That is nice.
So we're gonna for those of you that are already on board, we're gonna give it another minute or two, and then we're gonna get started with a couple of topics, and then we're gonna open it up for questions. So hopefully you brought some questions today, and we'll do the best we can to answer them.
Yeah.
Hey, Steph, are you planning on using that square footage advisory that comes out tomorrow, or is that something you've even thought about?
I think I'm gonna, if it's applicable, if there's like conflicting stuff, but other than that, unless we have to, I don't see the need to do it.
Yeah, I can see
yet.
it becoming an issue for some liability concerns down the line.
Yeah. But we'll see. We'll see.
All right. Well, I'm going to get started so we can get done on time. So good afternoon, everybody. I'm John Giardinelli. This is John's Rants. What we're going to do today is we're going to talk about a couple of topics. Then we're going to open it up for questions. If there aren't enough questions, we have a couple of other things we could bring to your attention, but I'd really like to hear what you guys think. With us today is the association's president, Stephanie. President Stephanie, why don't you tell everybody what's going on at the association, and then we'll jump right into the new forms.
Sure. Hello, everybody. Thanks for joining us again for another great episode of John's Rants. It's kind of fun that we're doing them more live this time. But from the association, we are, just a reminder, we're doing everything we can to serve our members. So if you guys do need anything, please do not hesitate to reach out. There's staff in the building. So if you need anything, just let us know and we'd be more than happy to assist. And then just a reminder for today, any questions you have or comments, please put them in the Q&A box, not the chat. Cody and I are monitoring the Q&A box. So we'll take it from there. Back to you, John.
All right. Thank you, President Stephanie. Couple of things. First of all, real quickly, I'm not going to go into any great detail, but you can go onto the CAR website. You've got some new forms coming out tomorrow and some revised forms. So real quickly, you've got two brand new forms. They're both advisories. One is the property visit and open house advisory. It's kind of a ironic twist that we have an open house advisory, but we can't have open houses. So we'll talk about that a little bit today, and I'm sure there'll be a couple of questions about open houses. So, but be aware that this is a forum that's going to talk about things like just advising people about things they should be careful of at open houses. For example, video cameras and audio taping and pets and safety concerns like wearing the booties on a slip and fall, and then what to do about your children. So it's a pretty good forum. Take a look at it. Like I said, it'll be available tomorrow. It's PVOH is the call number on the form. Then we have a square foot and lot size advisory. Stephanie made a real good point before we went live that it is not a mandatory form. It's a form that has a little matrix in the middle of it so that if there's a concern, and this is coming from Stephanie, I think it's a really good point. If there's a concern of some sort about the form, or excuse me, about the square footage, this will give your seller, and not you, but your seller, an opportunity to indicate where the information is coming from, and then there's a huge warning in there advising the buyers to do independent analysis. Like I said, it's not a mandatory form, and you need to be careful that you don't use it yourself because, again, these are disclosures coming from the seller. Now, and there's no place, frankly, for you to even sign the form. There are going to be 11 revised forms tomorrow. They're revising a whole bunch of the landlord-tenant forms relating to notice, because as you know, on January 1st, we integrated into California law some rent control, which requires landlords to provide certain specific notices to tenants. It expands the notice for pay rent to quit. Instead of 3 days now, it's 3 days plus weekends and holidays. So there's all kinds of notices. There's the notice to change terms of a tenancy. There's a notice to quit, a notice of termination of tenancy, a notice to perform or cure a covenant, a notice to pay rent or quit, and there's also a change to the listing agreement that it can be used for some other purposes as well. There's also some changes to the RPA type forms. There's a change to the disclosure information advisory because there's been a very slight change to the transfer disclosure statement. They've added a box that can be checked off regarding other disclosures that you may want to attach to your TDS form. And so in the advisory, there's an explanation of why they did that. Then there's a representative capacity change, and then there's a change to the septic inspection, the seller instruction to exclude, and of course the TDS itself. So that's what's going on tomorrow. For those of you that are realtors, which is hopefully everybody, that means that you're getting it automatically. There is a matrix at the CAR website that will kind of summarize each of the forms. Cody and I were going to, Cody and I were going to do a newsletter. We may still, but frankly, time and all of that, and just the crush of things that are going on right now have prevented us from doing that. Yes, ma'am.
Can I mention something in regards to the TDS, which Gov Hutchison has been
absolutely
going after it and reminding everybody of it. And during my sales meeting this morning, we had a big talk about this too, which, just a reminder, with the transfer disclosure statement, it's not complete unless all the boxes are checked, every question's answered, explanations are provided for yes. And as an agent, yes, we're not filling it out, don't fill it out. But review it prior to turning it over to the buyer to make sure it is complete, because if it's not, that right of rescission kind of kicks back in for a buyer. And
there's actually a case pending up in Los Angeles to discuss that very issue. And so it's a good idea to make the form as complete as you can. As Stephanie said, do not fill it out yourself. If you had the form done sometime early in the representation, but some time has passed, make sure before that form is transmitted over to the buyer's side that you ask the seller if there have been any significant changes. So you want to do that. Well, I'm going to move to another topic that's not very pleasant, and that's fraud. We're all working in unprecedented numbers online. And of course, that means that the bad guys are out there in all sorts of different ways. One of the top realtors that I know yesterday pointed out to me that there's been an uptick in Craigslist type fraud, situations where people will see your listing, they will then turn around and put it on Craigslist as if it were their listing, rent it out, get a deposit, get a down payment, or a first month's rent check, and of course the people in good faith think they have rented an apartment. In some cases, they've actually taken possession, which of course creates all sorts of problems for the owner of the property. And of course, the bad guy keeps the money, and a lot of people are being victimized. It's been a problem, frankly, for the last couple of years, but of course now with what's going on and the fact that everything's being done virtually, it's an even bigger problem. Seeing a lot more hacking. So for those of you that are doing any kind of a transaction, make sure that your buyers, your sellers, your landlords, your tenants get a copy of the wire fraud advisory. Read it yourself, obviously, but then make sure that you are giving that document, because again, what they're doing is they're hacking in and they're diverting money from either escrows or accounts. The other thing that they're doing is they're doing what's called phishing. It's spelled with a PH. But what they're basically doing is they'll send you an email. I got one this morning. Basically, it was an email from, what's that? Oh,
Phishing. I'm sorry.
Oh, okay, sorry. And if you click on, I also got one yesterday from Chase Bank, which is a place where I have an account, telling me to click on because there's been a hole placed on my account. They don't do that. The IRS does not send emails. Social Security does not send emails. But this is a way to get into your system, and then they can browse around, find your confidential information. And again, it's due to the unprecedented nature of the economy and the use of remote work. So be careful of all your rental listings. If you've got a property for sale, I know that Stephanie, you talked to Mary or exchanged emails with her about the idea of putting something in the MLS saying this property is not for rent, making it clear the property is not for rent. I know that I think that's a very good idea. And then just to be safe, make sure you're covered, make sure you understand your office's insurance policies, that you're covered for cyber fraud, have written policies in effect so that if in fact something does come up, you can point out that you followed your policies and you were not negligent. Legislation. Now this is John's rant. So unlike this morning at a breakfast meeting where I had to be a good boy and I was an invited guest, this is my rant. The legislature is out of control. That's my personal opinion. That's not Stephanie's opinion. It's not the board of directors or Phil's opinion or staff's opinion or maybe even Cody's opinion. That is my opinion. They are out of control. We are seeing landlords who haven't been paid rent in months, and what's their solution? To make it even more difficult for landlords. We're seeing that employers are having a difficult time making ends meet, so they're refusing to put a delay on the minimum wage, and they're putting more burdens on employers, both large and small, expanded family leave, things of that nature. But there are three bills that I want to bring to your attention. All of them are, I'm not going to even talk about the bills that you guys have defeated. Your lobbyists, both Christine and Tim at the board and Sanjay up in Sacramento, as well as the people at the federal level, are doing a magnificent job. But like the little Dutch boy, they've only got so many fingers that they can put in the dike at any one time. And the dike is overflowing. And so, but they are beating back some of the, frankly, insane laws. But there are three that are still going forward. One, AB 1436 is one you've heard about. Tim and Christine have sent you information about it. They've asked for red alerts, but it's still alive. And actually, it's the bill that would prevent landlords from collecting rents up to 15 months after the governor lifts the emergency order. So that could be a year from now. And then whatever the unpaid rent is, a landlord would be required to take that rent payment in increments up to 15 months. That is AB 1436. It has gone through the Assembly. It has been modified. It is now sitting on the Senate floor. The good news is the Senate is in recess for the summer because they worked probably 2 whole weeks, and so they needed a break. And now they're taking a break and probably out campaigning for re-election. And as you can see, this is my rant, so I'm ranting. It's crazy to do this. While I understand the need to have something for those renters who truly do have a financial issue, right? They've lost their jobs, they've had their hours cut back, they've had to stay home to care for a sick person or to care for children because they can't get anybody to watch their kids and there's been no schools or daycare. I understand that. And those people should be worked with and figure out how you can deal with them on an economic level that allows them to not be evicted, to stay, and to pay back what is owed, either by negotiation or in some other manner. But we all know that there's a good 10% of the tenant population that's simply not paying because they don't have to, right? and whether the law will be narrowed to deal with only COVID-related financial issues or whether it'll be a shotgun approach like they're doing right now, we'll have to wait and see. But that bill is on the floor, and it would be crazier except for the fact there's one even crazier. And that's SB 1410. And that is a bill that will give a tenant up to 10 years to repay. It has been, I'm reluctant to talk about it because it's what Christine calls a gut and amend bill. It was introduced back in April by the same people that brought you rent control from San Francisco. It is been amended 5 times now as recently as June 19th. I think that was Friday, might be Thursday. And so I'm reluctant to talk about it because it's gone through so many changes, but it's at its core will be crammed down provisions, not unlike what the bankruptcy court does, and it will give tenants up to 10 years to repay, because we all know that people rent apartments and stay in them for at least 10 years and will pay these debts back. So that's insane. That's actually still alive. There's also AB 3260. That is a bill that probably in some form will pass, and it is a bill that will give tenants the ability to pay their deposit in one of 3 ways, either by paying in full, by paying over 6 months, or by posting a bond to cover the deposit. In talking to some property managers and some others, I think it's going to hurt the people that it's actually meaning to help, Stephanie, because if most property managers, I've been told the general rule is even though they can collect 2 months, they really usually only take 1. Well, if I'm going to have to wait 6 months for my money, if that's what the prospective tenant chooses, then I'm going to charge 2 months rent rather than 1. So we'll see how it looks in final form. Fair housing issues. We had, for those of you that attended last Wednesday's legal panel, we had Brandon Butler from the Department of Fair Housing, and I just want to reiterate just a couple of things that he said. Remember, the only characteristic, whether it's in rental property or whether it's in sales property, the only characteristic is the ability to pay and the financial qualification. If you're dealing with anyone because of a characteristic that's protected, race, creed, ethnicity, gender identification, military status, immigration status, language choice, all of those things, if that's the reason you reject somebody, or if that's the reason you choose somebody else, you could be open to a fair housing violation. Disability issues are the #1 cause, so be very careful about any claim of disability or of protected status. If it's something to do with race or military, there's a thing called disparate impact, which means even if you don't intend to discriminate, you may be discriminated simply because of the way these policies affect certain groups. For example, if you discriminate because a person has a criminal record, well, because more people of color and more people of certain ethnicities that are not Caucasian are in prison, that kind of burden will fall on them to a greater extent than a Caucasian would fall. So be careful of that. Familial status, age, even if it's benevolent, treating elderly people differently, and of course, treating children differently, that can be a real problem. And then pets. Pets, you can have a no pet policy. It's perfectly acceptable, but service animals and companion animals are not pets. So if I come in with a dog that is a service dog because I happen to be blind or I'm mobily impaired, or I have a companion animal because I have a verifiable anxiety of some sort, then that pet or that animal is not deemed a pet, and I don't care what your policies say, you're going to let them in with reasonable accommodation. And there's all kinds of questions about that. Signage. I talked to Lori Smith this morning, who's one of the 2 best professional standards administrators in the state of California, and she works very closely with the other one who's the best, who works for us, Linda Conaway. And the two of them are getting lots and lots of phone calls about sign. Lori told me that over the weekend, she had over 20 calls about by members who are calling in people that have open house signs. And here's where the problem really and this I'd love to hear from Stephanie on this. Here's the problem. In and of itself, putting something on a for sale sign that says virtual open house or something like that is in and of itself probably not a problem. The problem is you better be really, really tight on how you control that situation, because the real problem, and those 20 calls that came in over the weekend and calls that are coming in all over the Southern California area to other boards, is that people will see that sign, they'll stop. You're not there to control things. No one has an appointment. The seller isn't necessarily clear on what the obligations are. You have ultimate responsibility to make sure the house is clean, wiped down, all the stuff is available, the signs are up, all the things we've been talking about for the last month. And there's a problem. People are getting in. And of course, when that happens, guess who's going to get blamed? You are. So be careful. Make sure that in your MLS, you make it crystal clear. These are by appointment only. Put some type of a control on your lockbox. I don't remember what that's called, Stephanie. I remember Barbara talking about it. There's a process where you can control that.
I can't remember. It's something code.
Yeah. So find out what that is. Talk to the lockbox people. But the bottom line is this: if you're going to have, remember, open houses are still not allowed. Now, we've been getting questions about when they will be allowed, and we have an answer for you. We don't know. It could be next week, it could be next month, it could be 3 months from now. The governor has given no indication that he intends to lift the no open house sign. I've heard that from CAR, I've heard that from other lawyers. I know Stephanie's heard it from her conversations at CAR and NAR. The bottom line is that you cannot have an open house. So if you're going to do an open house, which is really a virtual showing, then you're inviting trouble, because if someone comes in or groups come in, then you might have a problem. The other thing we've been seeing, and I was mentioning it to Cody, I don't know if I told Stephanie, but I saw a Facebook thing over the weekend where this guy was bragging that his market is so hot and he's doing such a great job, because you guys always put that on your Facebook, what a great job you're doing. I'd much rather find out what you had for breakfast, but be that as it may, you're putting that on there. And he actually posted a picture of 4 or 5 couples standing in line to get into his showings, right? And just inviting difficulty. Cody and I were told, we did a program up in Ventura, and one of the members up there who's in the same MLS that you are said that he saw a listing where the realtor actually said, "I'm not going to wipe the property down after every showing." No problem, because Cody and I are wanting to take some vacations, and the money that we'll earn from defending those kinds of brokers ought to get us pretty nice trips, don't you think, Cody? So just be careful. I understand these rules are cumbersome, in some cases probably unnecessary, but the law is the law. And if I'm a plaintiff's lawyer and I have a client who got sick, and I start doing some discovery and realize Stephanie did what she was supposed to do, Cody did what he was supposed to do, I can't find anything wrong with what they were doing because they went to their houses, but you weren't following the rules, I'm going to make an argument that it's more likely than not that my client got sick on your property. So just be careful of that kind of stuff. We don't know where this is going to shake out. We don't know we know the legislature has already created one presumption, which is that if you work for an essential business, it is presumed that you got sick on the job. So they could easily create other presumptions saying that if you go to an open house that did not follow the rules, it's presumed that's where you got sick. I'm not going to be surprised if they do that. I don't know if Cody agrees with that. I won't be surprised if they do that. So be careful about signs. Be careful about all your advertising, but especially about signs. Yes, Steph?
2 things. I would just say, be very careful about signs. Don't use the directional. You shouldn't be really using directional open house signs because it could be considered misleading to the public. Even if it says virtual, I mean, people miss stuff all the time. And then we were talking about that lockbox code, and it slipped my mind. Both Sherry Kelly and Robin Taylor reminded me it's called the call before showing code, CBS.
Okay. So those are the kinds of things you need to do. Again, I understand. I've told Stephanie I'm thinking about putting my house on the market. It's too big. I'm old, and there's other things I'd be rather doing than wandering around a big house. So when I go to list my house with my realtor, I'm going to want it sold. I understand that that's what you're there to do. Find buyers good houses, find sellers good houses. And we want you to do that. Everybody wants you to make a living. People want properties transferable. There's all kinds of laws about alienation and transference of property. However, whether you agree with it or not, and I can rant away if you'd like me to, but the fact is that the law is the law, and what I am deeply concerned about, besides ultimate liability for realtors, I am deeply concerned about the fact that this governor is seeing a spike in the pandemic right now. There's numbers are going up, and I'm afraid that he's going to use somebody or some industry as an example and shut him down, and I don't want it to be organized real estate. So the MLS, just be aware that you've got some great tools available. Go on their website, take a look at what Ed and what Jeff and those guys have put together for you, and Rob Larson, and learn it, because he's got all kinds of ways for you to get around this. He does not have an open house capability, and according to Ed, there's Zoran, the attorney for Sierra Millis, there's no present plans to reinstitute one. They do have virtual open houses, however, and also be aware that there's a $2,500 fine for violating the new coming soon rules. And then lastly, Cody, I want to turn it over to you for just a few minutes, just to lightly talk about some best practices for reopening offices. I don't know, Stephanie, are you guys thinking, or have you already opened up your office? Or are you thinking about starting to do that?
We are. We're doing like soft. We're very blessed in the fact that our office is so segmented. So we don't have, everybody has individual offices. So we're not, dealing with some of the stuff that a lot of other brokers are.
Right.
And that's, I know, one of the things Cody's going to mention, because not everybody is blessed like that. So Cody, why don't you take a couple of minutes, and then we'll open it up for questions. So get your questions ready, kids, because we're going to open it up in just a second.
Yeah, so thanks, John. I want to start off by saying, like Stephanie was just mentioning, every office is different, and none of these are a one-size-fits-all. I'm working with a lot of employment attorneys right now and figuring out how to facilitate opening religious entities, churches, small businesses, big businesses, and there isn't really a one-size-fits-all. It's super individualized. So what I'm going to do is just go through some kind of high points of things that people often overlook or don't think about, and just kind of get people's brains moving on potential directions that may go. So we'll start off by saying, take a step back. If you're opening up a brokerage, if you're opening up a small business, whatever the case may be, maybe you have a different business. Take a small step back and think, okay, what does this look like going forward? It's not, okay, how do I reopen exactly as is? That shouldn't be the question. So the threshold question needs to be, what does this look like moving forward for us? And what I mean by that is that staggered work breaks? Is that restructuring your office? Is that putting more space between employees? If desks are right beside each other, maybe it's turning them in a different way in the room. It can be small things, but ultimately it can help to safeguard you against potential allegations later, which we're already seeing. Over the weekend, we saw quite a few things where people opened up status quo, and before you know it, you have somebody who is being tested positive, and what did they do then? They opened up status quo with nothing in place and no plan, and that's becoming common. And so that's what we're trying to avoid. So there's some ways to help that. First, I've seen individuals use the PRE, which is really kind of an interesting way to use it, right? Put it in front of your business, put it at the doorway, or get something similar to it. Yeah, see? And what it does, I think I like it because it preempts conversations. I see it already where people walk in holding a mask, like, am I going to be required to wear it here? And it preempts that conversation before they get face-to-face with your secretary, your staff, anybody. Put it on the door. They'll know the expectation when coming in. They'll know the expectation as to what to touch. The other thing is put hand sanitizers out for your staff, for visitors, put them at the front, and if you can, make them touchless. They're really hard to get they're really hard to get right now, quite frankly. Everyone's looking for touchless faucets, touchless hand sanitizers, touchless paper towel dispensers, and all those things are really good for your workplace, but you have to be realistic about the fact that they may be unavailable. If you can get it, or if you have it and maybe just haven't replaced the batteries or whatever the case may be, make sure it's up to date, replace it if you need to, do what you can to make that as touchless as possible. And that's what we're really recommending for people. One of the other things is alternating breaks and work shifts, or to the extent that you can have some people work from home, have them work from home to minimize the amount of people who are overlapping in the office. So if you have one or two agents who have the ability to work from home, maybe bring in some staff who can be farther apart, whose lunch breaks won't all overlap in the lunchroom, whose rest breaks won't congregate all at the same time with 10 people around the lunchroom. That way you just, again, minimize those inter-office interactions. While we're all happy to have the inter-office interactions, and believe me, I miss them as well, it's just kind of part of this slow reopening process. And I think it's important to keep that in mind moving forward. One of the other things that I want to touch on when reopening, though, is a policy for figuring out what to do when somebody tests positive. I see it often where people get the test and go, oh, well, my employee's positive, what now? Okay, well, that's the question that you should have beforehand. Is there going to be reporting? Are you encouraging your employees when they have symptoms to stay home? Maybe implement a policy that has a more flexible leave, whether that's sick leave, whether that's permitting remote work in certain circumstances, whether your secretary walks in and they have a really bad cough one day. Well, maybe you should just go home, work from home today, or take a sick day, whatever the case may be, just to minimize that liability and exposure. And the other thing is to figure out inevitably what your procedure is going to be when somebody reports it positive. One thing to keep in mind is a lot of people put out business interruption insurance claims and tendered them at the beginning of all this. And I know, depending on your policy, certain ones won't cover that, just based on we saw quite a few that were refusing coverage based on the fact that it wasn't necessarily an ordered shutdown, or that it wasn't a closure because of a fire, or because one of the employees didn't have it. When an employee reports, make sure you go back and check that policy, because a lot of policies are covering infectious diseases for business interruptions, and that coverage may now be applicable even if it wasn't before. So those are kind of generally the high points. Obviously, there's a lot to think about there. There's a lot to contemplate when reopening the business. We're happy to help you through that. I know CAR has a bunch of resources behind it. I believe PWR is posting a bunch on their website as well. It's just, there's a lot of information out there, and we encourage you to just take it before you open it, before you go in status quo, and really tailor it to what your particular needs are going to be. Stephanie, do you have something to add?
Yes. So for the brokers that are on the line, I see there's a good handful of brokers on. CAR has great resources. The BPPP, say that 8 times fast, is a great start, and that's something you need to adopt anyways. But then there's also a sample prevention plan, which we have to have in place anyways, where you can edit that document to really adhere to your own office. And that's been a great resource as well.
I just think it's also worthwhile to as a broker, to set the policy for the office so that everyone is on board, not that each person is making up their own policy. If you're like Stephanie and you have a whole bunch of agents, it's absolutely, in my view, essential that everyone listen to what the broker wants to say. First of all, you're creating a scope so that if somebody ignores your policy and you're not aware of it, you've got a defense that it wasn't done intentionally, but also that everybody's doing it the same way, and people might have great ideas if you talk it through with your attorney, with your office manager, with your leadership, whatever you have, or frankly just think about it yourself, then I think you're just going to be better off. The other thing is that if you are a relatively small office, don't stray too far from the CAR proposed BPPP, because it was well done. What they did is they took the OSHA stuff and they converted it into a policy for you guys. So frankly, it could be adopted verbatim, although if you're an office the size of staff's probably going to want to customize it a little bit to your own needs. I have a question, and I don't know the answer, and I'm only going to throw it out because it occurred to me while I was listening to Cody. So we now know that if you're an essential business and you're allowed to reopen, that anyone who gets sick will be presumed to have gotten sick on the job. So this is what I'm going to research for the next time, because only a lawyer would think of this kind of craziness. Will your workers' compensation carrier take the position that if you don't institute the types of protections that Cody is talking about, that you fail to comply with the law, and therefore the fact that an employee got sick on the spot is not a covered workers' compensation claim?
It's a good thought.
That's why I'm only 28 years old, but I look this way because I don't sleep at night, because these kinds of things keep me awake. No, it's seriously, I think of that. I had lunch yesterday with a corporate client whose wife is a workers' comp lawyer. I'm going to give him a call. But I think that's something we ought to hear about. I think workers' comp, while it's not a very sexy subject, is going to be a big issue, because Stephanie, don't you have to carry workers' comp for your agents under California law?
I do.
So a big bump in workers' comp premiums or in claim problems is going to affect good size offices as well as other non-realtor business. So a couple of last things. Cody has redone the advertising guidelines that are currently posted on the association's website. They're in my hands, along with about 1,000 other pieces of paper. I'm taking them on an airplane ride, and I will finish them. And come January the 6th, I think that's the Monday, we're going to give them to Lori, and she'll post them. And it includes things like your signs, what to advertise, coming soon, open house, all that kind of stuff. It's already there. We did it about 3 or 4 years ago. I think it was Ashley Richardson did the primary drafting, and then Cody took it from there, and he's updated it for current use and cleaned up some of the stuff that needed to be cleaned up. So it's a really good piece of work. I've already gone through about half of it. It's a really fine job. So once I give Cody the changes I'd like to make, we'll make those changes, and he'll send it off to Lori. And it's going to be under your professional standards tab. Just scroll down, and it'll be there, advertising guidelines, about 30 pages for free. The CPI, as most of you know, if you're going to raise rent, you can raise rent 5% plus CPI. Orange County and LA is 0.7. So that means 0.7. So that means you can raise rent 0.7% unless CAR and the CPI are wrong. So for right now, let's just go with that. And then that's basically it. We could talk for 2 hours, 3 hours, and wouldn't cover it all. There's just so much. And I feel for you guys, I really do. Just be careful. So with that, do we have any questions? I saw we have something in chat, and we have something on the Q&A, and I don't know if anybody's done anything else. So what do we got?
Yeah, if anybody has questions, either what John's talked about, or even I'm assuming if anything he hasn't covered yet, put them in the Q&A box. But John, I want to go back to the very first thing we talked about, which was those new forms that are coming out.
Okay.
There's the two brand new forms. We talked about the square footage and lot size disclosure and advisory, and that's more of if applicable, if there's discrepancies. But what about the property visit and open house advisory? Is that something that you see agents utilizing for every showing, and how would that be delivered?
I think it's a good form. I mean, the fact is that once you get past all the COVID stuff, I'm going to visit your property, right? And so while you can't have open houses, it's sort of a moot point right now for open houses. It does say property visit and open house. So yeah, I think, like I said, take a look at it, read it. You know, every realtor is going to have to make their own choice about, I mean, I know you guys have all kinds of advisories and all kinds of forms, but if you wait till the RPA is formed, it's too late. Your client's already been out to the property. So it was meant as a risk management tool. So I think it's to me, because I know that if you talk to CAR's MLS attorney, there are issues all over the state regarding people being taped without their consent or knowledge, being videoed without their consent or knowledge, issues people showing up with dogs, issues and being bitten. And so at least you have something to give them before they start going out. I don't think it's a bad idea. I think it's part of a package that might be included, particularly if you have an unusual type property. And then, of course, bringing kids to open house, not open house, sorry, didn't mean that. Showings today is not a good idea. It can't be helped sometimes, but if you can avoid it, you should. And there's a little warning in there about that. And then, about putting on booties and other safety issues. By the way, just so you know, gloves and booties are no longer required. So it's just masks, disinfectant, and wipes. I attended a wedding on Saturday, and instead of little bags of candy, they gave everybody hand sanitizers. Wasn't as joyous, perhaps, as a nice bag of mints, but it made sense. So these are the kinds of things you're doing. One other thing, Stephanie, and I'd like to hear your answer. We had a question this morning. I thought it was a really good question. Is that I don't see any duty that either the listing agent or the buyer's agent has to have the house sanitized when the seller moves out and the buyer moves in. But we've heard people say, you know what, it's still a good idea, figure out who's going to pay for it. Instead of a plant, maybe that could be your closing gift to your buyer, is to have somebody come in and do it. Negotiate with we have some affiliates, I know, because they've sponsored some of our programs back in the day. But again, it's something that at least should be discussed. I think it's a good idea. I don't know that there's any law that requires it, but I think it's a good idea that before people move into the new property, where there's been, anyone living in it for any reasonable period of time recently, that the property ought to be given a good deep clean. I just think that's a good idea. Who pays for it? That's really subject to negotiation.
Yeah.
What do you think?
I haven't heard of that being like set in stone as far as the law goes, but that's definitely not a bad idea. And I'm sure some people would definitely prefer that over a plant. So.
Yeah. To me, again, when you're looking at ways of limiting your liability, the fact is, if nobody's sick on the day of closing and you have the house disinfected, you've given yourself one more insurance policy against a claim coming down the line. And it's also a nice thing to do. So anyway, that came up this morning. What other questions do you have, if any? We've got about 20 minutes, so if there's any other questions.
Let me see. There's one about unemployment benefits, John. I can answer it. I was going to type out the
answer, I know nothing about unemployment.
So generally, my understanding right now is that unemployment benefits may be reduced in the next month or so based on the additional federal funding from the CARES Act. But your eligibility lasts about a year. Typically, under normal circumstances, you have to verify a continuing effort with continuing benefits like biweekly. But I believe I was informed recently that that's being ceased for the time being, and that you don't actually have to make those verifications to the same extent because of COVID. So the general answer is it can last for a while, but it's in the EDD's ballpark. I would work with them if you have any specific questions about your exact circumstances.
I think one of the hot button topics is, at least I've been hearing from our business clients, is that, where employees refuse to come back because they're doing better sitting at home. Yeah. And so, the refusal to have gainful employment, well, maybe in California, but nationally, I think that's going to be a problem. And then I was talking to my wife this morning. She does work in the HR field, and so one of her duties has been to shepherd through all the PPP loans and repayments and charting, making sure that the percentages are right and all that. And she was saying that they've tremendously liberalized a lot of the loans. So there's going to be a much easier task of proving that you use the funds appropriately. There's going to be an elongated period of time to use the funds, and actually a simplified way of establishing, instead of an 18-page document, which they were talking about, a much shorter, much easier document. She said there's even been talk that they will have no reporting requirements for the first $150,000. So if you took out a PPP loan for less than $150,000, you may not even have to do a report. So just keep an eye on all that. CAR has been doing a bang-up job of putting stuff on their website for unemployment and for loan forgiveness issues. So if you did take out a loan, keep an eye on things. Go ahead, Steph.
Oh, I have really two questions for you. We spent a lot of time last week on the legal panel talking about the clear cooperation policy, and we received quite a bit of questions, not necessarily today, but just in general. Can we do like a quick overview of the clear cooperation policy?
It was mandated by NAR. Each MLS was given until May 1st to institute a plan in their MLS rules for dealing with coming soon signs and for dealing with pocket listings. CRMLS, after a lot of study and a lot of drafting, created several rules. There's now a coming soon status. It's good for 21 days. It's not 21 days, you can renew it. It's not 21 days, then you can put it in some other whole category. It's not, where you can take it off and then put it back in. It's 21 days total. That's what was decided by the board of directors at CRMLS, is enough time to tell people your property is coming soon, okay? If you don't do anything on the 22nd day, it will automatically go to active. So you won't have a choice. So if that's not what you want to do, you're going to have to take an action. If you violate the rule in some way, the primary thing being that you start showing the property, and that's the key component of the do not. You may not show property that's in coming soon, because then you're showing it. That's marketing. That means it's active. So if you're showing property in a coming soon or something else that violates the coming soon rules, you're going to get a fine. The minimum fine is $500. The maximum fine is 1% of the sales price up to $2,500. And in Orange County, that pretty much means $2,500, right? And so they're going to give you currently today 2 warnings. 1 warning and then 1 not so nice warning. But what Ed made it pretty clear, Ed Zorn, the attorney for CRMLS, is that after a while, those warnings are not going to be so nice. And what they'll do then is they'll fine you if you want to appeal it, or you do it habitually. It will come to the board, and what Lori Smith will do is she will send it to grievance. And what grievance will then do is ask the question, did this person who habitually violated the coming soon rules, did he or she do that intentionally? Because if so, they will probably add to the $2,500 potential fine at the hearing an Article 1, breach of fiduciary duty to your client, because you're pretty much acting in your own best interest. 2, you're misleading the public. Number 3, you're failing to cooperate with other agents. And then Article 12 is that your advertising is not painting a true picture and is in violation. That could lead up to a $15,000 fine. As far as registration is concerned, if you're not going to put the property in the MLS within 1 business day after you take a listing, unless it's a pocket listing, which I'll define in a second, you must register that property. The SELM form is being revised tomorrow, and I'm not really sure how you do that, but you must register the property, not in 2 days any longer, but in 1 day. 1 business day. And then there's some restrictions on the what you can or cannot do with a registered property, but it's a property that's not on the market. In order to register the property, you have to meet certain criteria. One, which I think is not that complicated, but you and or the brokerage have had to have an executed agency disclosure agreement. In other words, that person is actually been or is a client of the firm within 1 year before you take that listing. That's kind of a 30,000-foot look at it. My strong suggestion is go to CRMLS's website. All the links are on the association's website, and explore. They've got some great little video tutorials. They've got all kinds of information. Nobody's out to get you. These were rules NAR said we're trying to curtail the abuses of coming soon signs because they were being abused pretty much across the board. And so that's why they did this. So,
kind of bouncing off of that topic in regards to assigned agency disclosure, assigned broker representation agreement can also.
yes, I forgot about that.
Yes.
Okay. What would you like to know? Well, go ahead.
Okay, so there's the exclusive broker representation agreement and the non-exclusive. The non-exclusive basically, is it just saying that if you introduce the property and show it, then you're entitled to the commission? Or
There's three different agreements actually. There's the buyer broker representation agreement, which has nothing to do with money at all. It simply says, it was basically drafted in response to a case called Field versus Century 21. Because Field versus Century 21 created this incredible standard that says that a fiduciary, someone representing a buyer, has a fiduciary duty to step into the shoes and know the type of information that a buyer might need to know in their position, which is really ridiculous. I mean, it's like saying you must have a crystal ball, it must be in good working condition, and then you must be able to figure out what your client's thinking. And so in order to kind of put that in writing, they created the buyer broker representation form, which really doesn't have much to do about money, but does pretty much say, look, if I find you a house and we go into escrow, this is what I'm going to do, and this is not what I'm going to do, and now you understand it. It's all in writing, no ups, no extras. The second agreement is a limited version of the exclusive, and it basically says, I'm only going to work, I'm going to be guaranteed X amount of dollars. I've hired Stephanie to find me a house. Stephanie's office policies are, and I'm making this up, I don't know what your policies are, but that they will not work for less than 2%, okay? Now, and so we signed that agreement. It's got all the same language in it that the non-monetary document has, but it says basically, I'm guaranteeing Stephanie's firm minimum of 2%. So if I decide to buy a house and the offering commission is 1%, basically I'm going to make up the difference between 1% and 2%. I'm promising Stephanie that I will make a monetary pledge that I will pay you that additional 1%. The reason I like that form the best of the three is because one of the problems is that people, I'm sure Stephanie, you've had this, where you're looking for a house for somebody and suddenly you see the house that your client might like, but they're only offering 0.5% or 1%. Now you have this quandary. I don't want to work for that amount of money, but I've got to show it to them because I have a fiduciary obligation to share all information, right? Mm-hmm. So that puts you in a quandary. I can tell you right now that if I had an agreement with Stephanie that I'm going to pick up the additional 1%, I'm probably going to tell her, then don't show me anything that's less than 2%. This conversation, Stephanie, I think you remember that I'm on that risk management group at CAR, mm-hmm. and that's a conversation we actually had. There's 12 lawyers that do what Goedl and I do, and we talked about that's a great form to get around the fiduciary duty issue, because now your buyer can say to you, then don't show me that because I don't want to dip into my own pocket. But then the other thing that it does is it does allow you the freedom to show those properties if your client's willing to give you the 1%. The third is the exclusive. It's basically the flip side of the exclusive right to sell. Okay, I'm signing with Stephanie, and I'm agreeing that if I buy any house from anybody, if I buy a house from Cody in another office, I'm going to give Stephanie whatever percentage of commission I'm promising her. Okay, I don't like that form, not because the form in and of itself isn't fair. And if you do that for, say, a 90-day period, that's probably okay. But according to June Barlow at CAR, the chief counsel for CAR, she's gotten a lot of reports around the state that a lot of agents have used that form for self-serving purposes, right? Stephanie's gonna make me sign for a year and then sit back and wait for her commission. Not Stephanie would ever do that. That's why she's the president. But the fact is, you do need to buy those goats. So, so that's the bottom line is that all three of the forms are great. Cody and I have had this conversation internally a lot. The Code of Ethics, Article 9, says you're to put everything in writing. I personally, and I've said this to you, Stephanie, if I were the king of the world, I would make one of those three forms mandatory. If you're going to represent a buyer, you ought to have a written agreement with the buyer. And I hear the argument, well, buyers don't want to sign it, blah, 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 blah. Well, what does that tell you? Maybe that buyer's not going to be loyal. Maybe that buyer is playing you. Maybe that buyer's playing the field. Maybe that buyer intends to accuse you of something down the road. But at the minimum, if they're not going to sign it, at least send it to them with a cover letter saying, this is the basic terms of my representation. Please do not anticipate me doing more or less than what this contract says. If you have any questions, call me. Or wait for somebody to sue you and keep our card handy, because the buyers are the most likely plaintiff in a post-close lawsuit, right? They bought a property, they don't like something, and they're going to sue everybody. And as a fiduciary, you've seen the jury instructions. I've shown them to everybody. It's a really tough road for the buyer's representative to defend herself without something in writing that can be shown to the jury saying, but that's not what we agreed to. Here's what we agreed to. I wasn't going to go look at permits. I wasn't going to go off-site. I wasn't going to do this. I'm not doing that. I'm not going to violate fair housing regulations. I mean, I just think it's a good form to have. And I wish they made it mandatory. I've had that conversation with CAR. Right now, nobody's going to do anything because otherwise we'll hear realtor heads exploding all over the state. But right now it's not going to happen. But I wish it would, because it would solve the problem. I will tell you, I think I mentioned this to you, Stephanie, that when I bought my properties in Tennessee, got a really great realtor. You remind me a lot of her, she a lot of you, because very young, very smart, very well accomplished, and was the realtor of the year in Williamson County. And before they would lift a finger, the first document they sent me was a buyer-broker representation agreement with a cover letter that said, review this, call me with questions, and sign it. When I get it back, we will commence blah, 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 blah. Okay? It wasn't any conversation about, please think about it. It was sign it, and when you do, we'll work for you.
Definitely.
And you know, it'd be kind of ironic for me to say, well, I'm not signing it since I've been screaming bloody murder for a year now, that everybody should be using those forms. So I just think it's a good idea. Unless you like the idea, you know, you like living dangerously. If you like living dangerously, rock climb. Don't do that. Yeah, do something fun. Go into a bar without a mask. I don't know. Just do something fun. What else you got? Anything else?
I have no more questions. Cody, do you?
No, I don't see any either.
Okay.
All right. So just real quickly, I'm talking to Lori Smith. I don't know if the board wants to do a property management class, but we're talking about, Cody and I put one together. We did it for the first time last week. It was really, really fun. We'll do another rant. We're going to do another legal panel. We're trying to figure out which guests. We're thinking maybe the Department of Real Estate guy to talk about, because one thing nobody's ever talked about in all this is, what's the Department of Real Estate's position going to be in all this? And so Lori and I have a contact at the department. We're going to see if he's available on the date that we've set. If you'd like to hear from somebody, let us know. Let Lori know, let me know, let Stephanie know, and we'll put it together. And then, you know, just keep an eye on the association's website. Keep an eye on CAR's website. Well, frankly, if you keep an eye on the association's website, the two GADs are just, I mean, they're doing a phenomenal job. They wrote a letter yesterday on a topic which I'm going to respond to this afternoon. And Cody and I were hard pressed to find something that we could add to what was written. They're just doing a phenomenal job.
They really are.
So you gotta stay in tune with this stuff. We'll keep you posted. Cody and I are every day we get up in the morning, and Cody and I, our first conversation was at 6:30 this morning, and it's just what we do, and it's what because that's our job to keep you guys abreast. And I know the board's been doing a phenomenal job. Steph, anything in closing coming from the board's perspective?
No, just like I mentioned before, if you guys ever need anything, let us know. We're here for you. And thank you for your support during these times.
Right, and thanks for attending today. This was recorded, so unfortunately for the people that didn't attend live, they can't ask any questions, so ha-ha. But for you guys, if you have somebody that you think whatever we talked about today might be of interest, let them know that it is recorded, and it'll be posted on the association's website sooner than later. Okay? All right. Have a great day. I'm going to go back and finish my Hallmark movie. I'm kidding. I've got another conference call I've got to take. Good luck, Cody, on that thing that we talked about. Okay?
Yeah.
Bye,
All right.
everybody.
Take care, kids.
Thank
Thanks
you.
again, Stephanie, for the help. It was really appreciated.
Anytime.
Yeah. Thank you, Stephanie.
Bye-bye. Thanks, Laura.
Bye-bye.